Welcome to our joint webinar partnership between Wohlsdorf Rosenthal, our national immigration firm, and DLA Piper international firm. I'm Farshad Oji. I'm the San Francisco partner of Wohlsdorf Rosenthal, and also I'm the second vice president of American Immigration Lawyers Association. I would like to introduce you to our guest panelist, Christopher Feldman. He's a partner, international partner at the DLA Piper Seattle office. We have also Sharina Garcia. She's a managing partner, Northern California managing partner of Wohlsdorf Rosenthal. And also we have Nathan Groh. He's a senior associate in Oakland, California of Wohlsdorf Rosenthal. Chris, if you could please introduce yourself, and then we go to Sharina and Nate.
Yeah, thanks, Farshad. Yeah, my name is Christopher Feldman. I am international tax partner with DLA in the Seattle office. I have a wide-ranging practice of helping on U.S. international tax issues for anything from startups to large multinationals. So I think I have good experience in understanding sort of the inflection points as you go through this journey with your company on the tax side. So looking forward to discuss today, and thank you.
Sharina.
Hi, I'm Sharina Garcia. I'm the managing partner based here in the San Francisco Bay Area for Wohlsdorf Rosenthal. I have been representing startups for over 20 years. It's one of my favorite clients to represent. I love watching it go from a seed all the way up to a big tree. So really excited to talk about this today.
Thank you, Sharina. Nate?
Hi, yeah, I'm Nate Groh. I'm a senior associate with Wohlsdorf, also here in the Bay Area. We represent people in a range of different industries, but as Sharina mentioned, we have a specialization and a special love for entrepreneurs and startups.
Thank you, Nate. We are going to be first in the first segment talking about the immigration, and then after that we will be going to Chris to cover the international tax aspect of our discussion. First of all, let's move to the second slide, the roadmap. In our immigration presentation, we will be talking very briefly of some basic terminology, and then we will go through the non-immigrant visa options for entrepreneurs and employees. Then we will be discussing the current challenges and state of affairs, and then at last we will be talking about the policy consideration of Biden administration. Now, next slide, please. So covering some basic terminology, Sharina, could you briefly talk about what is the permanent and what is the non-immigrant visa? What is temporary and permanent? Could you define that for us?
Sure. So temporary is like it says, you're coming to the United States just for a fixed duration. Like let's say you want to come in as a visitor, you plan to go to Disneyland post-COVID, and you plan to stay for a few months, right? Or if you're here as a student and you're coming here to study, then you're allowed to remain for the duration of your studies. Permanent is you actually want to live and work in the US permanently, right? You want to do away with having to renew a visa, and that's what we call the green card.
Green card, yes. Now, what is the difference between the status and then the visa and the petition? Because oftentimes you get a call and you say, yeah, I'm in the US and I have a 5-year L and I can stay for 5 years, right? How do you define that? How do you clarify that to your client?
Yeah, so what's really important you understand is that each visa type has its own requirements. Some you can just go straight to the consulate, get a visa and come in, like a visitor visa or a student visa. But others, you actually have to go to the government first and get pre-approval. And that's what we call the petition. And that's where you have to get what we call an I-797 petition approval. And once you have that pre-approval from the government, the USCIS, you then go to the consulate or embassy, typically where you're located, and you actually have to be interviewed for a visa stamp. And you know, you go through a whole process, and it's very similar to me when I went to visit China. I had to apply for a China visa to enter China, right? So you apply for a US visa, and once you get the visa, and you'll know it's a visa because it has your picture, right? And so that's your ticket to enter. So when you enter the US, you're greeted by the lovely Customs and Border Patrol officers who greet you warmly when you enter after your 14-hour flight. And they will ask you to present your passport, your visa, and also your petition, your approval notice, right? And when they interview you, what's the purpose of your trip? How long do you plan to stay? They will then issue you admission into the US, which is what we call your I-94. And that will dictate exactly how long you can stay in this country. So the visa lets you in, the I-94 lets you stay.
Yeah, and it's very important that every traveler that comes to the US, they have to look at their I-94, because sometimes you have a petition for a long validity period, but oftentimes we see our clients, the employees, come to the US and they have been admitted to the shorter validity for a number of reasons. Even they have like a 2-year petition, but they have been admitted for like a shorter period because their passport expired. And that creates a hurdle for them in terms of changing status, adjusting status, and perhaps getting an extension. Now, Nate, could you talk about what is change of status, what is extension or adjustment?
Sure. So as Shireen is mentioning, immigration status is the amount of time you are permitted to stay in the US and in which category. And this terminology can get confusing. So when we talk about a change of status, that refers specifically to a change from one non-immigrant category to another non-immigrant category. For example, if you're an aspiring entrepreneur in the US in F1 student status, and you get selected in the H-1B lottery, you can apply to change status from F1 to H-1B. So that's not to be confused with an adjustment of status. Adjustment of status refers to the transition from non-immigrant status to a green card. So, for example, if you're the aforementioned entrepreneur in H-1B status and you qualify for, let's say, a national interest waiver green card, then you can adjust status while in the US to obtain a green card. Extension of status, which Farshad also mentioned, is when you're in the US in a particular category and you apply to lengthen that status, to extend it beyond your current I-94 expiration.
Ed, could you also briefly talk about the work authorization, the unrestricted or petition?
Sure. So just briefly, so work authorization comes with some categories of non-immigrant status. We're going to talk about some of those categories on the next slide, where you automatically get work authorization. For other categories of non-immigrant status, you have to apply separately for work authorization. For example, a recently graduated student, or the spouse of some workers in certain non-immigrant categories. They don't automatically get work authorization, but they can apply for it.
Thank you, Nate. Now, next slide, please. Let's talk about some non-immigrant visa options. Obviously, we can't cover this. We're going to be briefly touching some of the specific visas and the challenges and key points that we can take away. For the comprehensive list of visas, you can refer to our website. Also, we have been circulating a handout that you can get more detail on those. Sharina, I'm a startup and I come to you and I say that I have just graduated and I have this great idea. I have a VC that is ready to fund me. What are my options? What can I do to be able to work here and start my startup?
Sure. So usually if you're a student here, you get your EAD card, which Nate had mentioned, which allows you to work, right? But you want to transition, you want to change that to something else that's a little longer in terms of time period. And the most common one is the H-1B, which is a temporary work visa. It is subject to a numerical quota, so there are caps to that. But what we typically do is we explore all different options, but usually it leads us to the road of the H-1B. And when you are a startup, right? So there's a lot of myths out there that a startup can't sponsor an H1, you don't have enough income, you don't have enough employees. I have done hundreds of H1s for the first employee on an H1, and that's the only employee. So it can be done. We've also done it where you may not have enough funding, and so you can only do it a part-time H1. So we have a lot of creative ways to handle H1s.
So, Sharina, so what do you do about the form itself? Let's say it is asking, the form asks I-129 that, do you hold any share of the company that is sponsoring you? How do you answer that? And if you answer yes or no, is it going to be detrimental or change the?
It depends, right? So number one, you have to be honest, right? So you have to tell the truth. And so if you do have ownership interest in the company, you have to disclose it. Now, the percentage of ownership is where we hit the problems, right? Because if you have majority ownership, that's where the government starts questioning whether there's actually an ability to fire you, right? Because there has to be a valid employer-employee relationship. If they don't see that, then you can come across problems where they don't feel that you will actually qualify for the H1 because there is no valid employer-employee relationship. So we work with the companies to establish that and to determine, the percentages of ownerships. And, that's typically what we do.
Great. Now, in terms of if I have funds available and I have my parents is gifting me $500,000 and I'm here and I would like to start my business, how would you be able to help me with that?
Well, so it depends on what country you're from, right? So there are treaties established that allows investors to come into the US. That's what we call the E2 treaty, right? So let's say you're from the Philippines, right? And your parents gift you $500,000. That's great, because with that $500,000, you can qualify for the treaty investor visa. And what you would have to do is come up with a business plan and be able to show exactly what your planned usage of the money is, that it's committed, it's invested into the entity, and that you plan to hire US workers.
Yeah, not to mention if it was 2 years or 3 years ago, you could use that 500,000 to actually apply for a green card through EB5 Regional Center. But now
not anymore.
Exactly. Now, how about if I have startup a company in a foreign country and I have a great idea, and then I come to the US and I look into bring a US branch and open up a US branch and expand my operation here in the US. What are the options there?
Yeah, so that's great. So the most common option is what we call the L1 Intercompany Transferee. So you've worked for the overseas company for at least a year. Physically, you've been there for a year, and then you're coming to the United States to open up a branch, subsidiary, or affiliate. And what you can do is we can apply for an L1 visa for you, right? Typically it's an L1A, and they will give it to you for 1 year as a new business.
Now, Nate, I call you and I tell you that, hey, Nate, I'm here on a visitor visa, and it's a visitor for business. It's a B1. And I'm going to open my company and I'm going to start talking to VCs and start basically establishing my company. What do you have to say? What is the issue with that?
So a bit of a warning flag pops up whenever we talk about coming into the US B1, B2 status, or ESTA. This is a visitor status, and there are restrictions on what you can or cannot do in B1 or B2 or ESTA. And the line is a little bit fuzzy. So gainful employment in the US is not permitted. You can, however, engage in commercial transactions. You can negotiate contracts. You can consult with business associates. You can investigate investment opportunities. So as you mentioned, Farshad, coming in perhaps to meet with a VC, that's permitted, but you can't go too far down the road of establishing and running your own business in the US. I think I can illustrate with an example. So I represented an entrepreneur who wanted to purchase luxury residential properties and start a business offering short-term rentals and luxury services for tourists. So that now seems like a distant, faraway dream in the world of COVID. This was before COVID, obviously. He eventually qualified for an E2, which Sharina talked about. But before he did that, he came in on ESTA and was able to look at properties he wanted to buy. He hired his first employee. He met with other professionals, lawyers, a broker. But of course, we had to advise him that he had to be very careful and not stay too long. And he had to refrain from actively managing an operating business while he was physically present in the US on ESTA.
Yeah, and also it's very important at the port of entry when you come to the US, you have to be very honest with the CBP officers. If you're here to discuss with your attorneys or talk to VCs, they are willing to give you a visitor for business purpose, but if you tell them that you're coming to visit friends or parents or go to Disneyland, and they look at your computer and they go through your emails and they see that you have an appointment with a VC, that probably would be the end of your trips to the US. So we have to be very careful and be forthcoming with the CBP officer. Now, quickly, Nate, let's shift to O1. In terms of, let's say I come to you and I say, yeah, Nate, I have a PhD in physics, and I want to be able to get an O1. Am I eligible for that by having a PhD? How do you determine that?
Sure. Yeah, the PhD alone does not make you eligible, but somebody with a PhD may have a lot of the criteria. O1 is a category that is really made for people with PhDs or people, entrepreneurs, people in the startup world. It's a great fit. You know, I've worked on O1 petitions for people in lots of different fields, artists, scientists, researchers, and some of these people are very humble and polite, and you have to drag out of them what makes them extraordinary and what qualifies them for an O1. I don't have this problem with entrepreneurs usually. Entrepreneurs have a very good idea of what makes them extraordinary. And
how about if I don't have a PhD and I just have a master's degree, am I out of luck?
No, not at all. There's no degree requirement. What they look at is a set of criteria, and you must meet at least 3. So for somebody who's a tech entrepreneur, for example, we represented a tech entrepreneur who developed patents for data security. And he started a company and he commercialized his patented technology and generated a bunch of revenue. So based on that, we were able to argue that he had an original contribution of major significance in his field. That is one criterion that helps you get an O1 visa. As part of the PR push for his company, there was, of course, a bunch of press and media about him and the company. That meets another criterion. If you serve in a critical or essential capacity for an organization with a distinguished reputation, that's something that lots of entrepreneurs do, of course, with their own companies. That also satisfies a criterion for O1.
So basically, it's not a one-fit-all. We have to really look at the specifics of the individual and determine whether they're eligible or not. Now, as we know, all of this non-immigrant visa, one of the characteristics of the non-immigrant visa is for specific purpose, specific period of time. Now, I'm in an L, let's say, on my 5th year. Sharina, what are my options? What can I do?
You're on an L1 and you're on your 5th year. You're basically here. You've established the company, right? And hopefully within that time period, your company has been growing, right? And you've started to hire US workers. It doesn't necessarily have to be profitable, right? I have represented many startups, and startups usually are not profitable for a long time. And that's okay.
One question, Sharina, am I late actually in the 5th year? What do you think? I mean, do I have to wait for 5 years, or can I come in immediately?
You know, for L1A managers, what I always tell them is you start up small, right? Every startup small. You dream big, right? But things happen along the way where you may not get that next round of funding or things like that. And what you have to really do is show that there is a growth pattern to what's been going on. You're not managing the day-to-day operations, you're actually bringing in a team. And that's how you can successfully get a green card as an EB1 manager or executive.
Now, also, we understand that some of these work-related non-immigrant visas have a parallel in the immigrant world. So not that it means that you can directly, because the misconception is that, oh, I'm on an L1 when I get my green card. There is no such a thing. I mean, there has to be filing application, meeting the requirements, and so on. So in terms of the, Nate, in terms of the O1, what are the options? I'm on an O1, and what can I do after that?
Sure. This is on the next slide. Let's skip to the next slide. So there is a immigrant visa category that matches up with the criteria for O1. It's EB1A, a category for extraordinary ability. And although it's similar, USCIS holds you to a bit of a higher standard, especially in the last few years with the Trump administration. Requests for evidence and denials for EB1A have become more frequent, even where somebody may have already qualified for an O1. So EB1A is an option, but just because you get an O1 doesn't mean you qualify for a green card.
Yeah. Now, obviously, there are options available for investors as well. I mean, if you have a E2 visa, it's not that easy that you can transition. But Shrina, do you want to briefly discuss that if you're on an E2, what are the challenges that if you want to go to the immigrant world? And
so using my Philippine entrepreneur as an example, his parents gifted him $500,000. And so the question now is, how do I flip that $500,000 into an actual green card, right? Because now I'm here on the investor visa, I can stay in, for an indefinite amount of time, as long as my investment's growing and the business is doing well. Then we look at the EB5, and our firm actually specializes in EB5. And there are other webinars there that discuss exclusively EB5, but just the core of the EB5 is if you have invested $900,000 in a rural or high unemployment area, or $1.8 million in a regular metropolitan area, and you're creating jobs for 10 US workers, then you can actually get a green card. And so if the origination of the funds for an E2 is yours, personally, it's yours, then you can grow that to be able to qualify for an EB5. But if your parents didn't, it was their entity that invested it, that's going to be a harder sell to be able to get to the EB5 program and a green card that way.
Yeah, obviously, I mean, every part of this, every section, you could have hours and hours of presentation to get to the details of them. For the interest of time, we're going to move to this next slide and discuss about the current state of executive orders and proclamations. Today is obviously the inauguration date, and the Biden administration took office, and we're going to be briefly talking about what the changes are coming and what we know and what we don't know. But at this time, we do still have these proclamations. And Nate, what can you tell about the COVID-19 ban?
Sure. So,
and why do we have the exclamation mark on it?
Well, it's a currently evolving situation. These bans have been in place for a while that bar travel to the US from China, the Schengen area, United Kingdom, Ireland, Iran, Brazil. President Trump actually announced Monday that he was rescinding those travel bans. However, according to President Biden's incoming press secretary, the Biden administration does not intend to lift any of these COVID-related travel bans. In fact, they are looking at strengthening public health measures around international travel. So the bans were possibly going to go away. President Trump said effective the 26th, but now it looks like they are going to remain in effect, at least for the time being.
So it's going to be to be determined. Now, in terms of the economic, the immigrant visa ban and the number of the non-immigrant visa bans, what is the current situation on that? Sharina? Do we know anything about what the changes are going to be?
We don't know anything, and everything is kind of status quo. So what we do know is that President Trump, before he left office, extended the H-1B, H-2B, L, and J travel bans until March 31, 2021. So we have a lot of our clients who are trying to pursue the H-1B visa for the first time and are outside of the country, and they won't be able to come in until this ban is lifted. And the only way to get around these bans, which actually has worked for many of my companies, is to actually join the Chamber of Commerce. And so I've been successful in bringing in my L1 clients because they've actually joined the Chamber of Commerce or the National Association of Manufacturers, which we call NAM. And the Chamber of Commerce, it's $250 to join. They issue you a letter that says you're a member, and then the consulate will actually issue you the visa.
And I've encouraged a number of my clients to register for U.S. Chamber of Commerce, and then you get in touch with them. They send you a letter. But I thought that only would be enabling you to get the immigrant visa. But does that also help on the non-immigrant? Like if you have an L or H, would that also help?
Well, it's all, the purpose for it is for the non-immigrant visa ban, right? So really it does work for the Ls. And so when you go in and you submit your application, then you show your letter confirming the company is a member of the chamber, they'll actually issue the visa. Like for my client, they're from Taiwan. They can just hop on a plane and come over, right? But if my client's from China, then I have another problem because there's a COVID restriction ban on them actually being able to enter the United States. So I have to deal with that secondary ban.
So this morning, early morning before the inauguration took place, there were a list of priorities and list of the bills that the Biden administration is going to introduce and some executive order priorities. What can we talk about, tell about those bills and executive orders?
Is that directed to me?
Well, I mean, yeah, we can. It's an open question. We can talk.
Oh, okay. I mean, it was. I mean, this morning and reading about the transition plan for Biden, I have to be honest. It's exciting because after 4 years of working in a very difficult anti-immigrant climate, for President Biden to introduce some of the things that he's talking about, which we list here, you know, clearing the family employment-based visa backlogs. Is amazing. You know, my clients from China and India, if that actually happens, it will really change the landscape of immigration.
And to supplement what you say, for the last year, one of the significant difference between the 2 decades of the practice that I had is that the unknown. Every day you would wake up with an unknown and the changes that would be coming. No clear path as to what strategy would work or not. And when discussing with the client, you had to bring really all the options available and the unforeseens to be able to have at least meaningful strategy. Now, in terms of the day one action on immigration, we should understand that there has been very, very pressing human rights and kind of humanitarian issues that had to be dealt with and handled that are pressing. So what we have seen so far from the Biden administration is that those are taking the initial priority that has to be handled. But we are also anticipating that there are going to be some upcoming changes and actions next week that we are really tuned in and we are eagerly waiting to see what those changes are. Do we want to quickly talk about this, Sharina, this slide and say what?
I think it's exciting, but I wouldn't get too excited because it's just a bill. We haven't read the bill. We don't know exactly what it says in the bill. I assume it will come out sometime today. But it still needs to pass, right? It still needs to pass Congress. And so, you know, will we see parts of this? You know, all of it? has to be told, right? Soon to be told.
Yeah, but for sure, we know that the Muslim ban, travel ban, is going to be lifted. That's the part that is.
Yeah, and I think the nice thing that we can look back on is during the Obama-Biden administration, there was a strong push for entrepreneurship, and there were a lot, like the task force on they created, and entrepreneur in residence and things like that. So I'm really hopeful that there will be a path for our entrepreneurs to come and contribute to the U.S. and revitalize our economy.
Yes. Can we go to the next slide? Nate, what are the policy considerations and the priorities for the Biden administration? And what is the current state of immigration? I mean, how much backlog did we have? How much backlog do we have now? What are the priorities? Can you quickly tell us?
Sure. Right. Yeah. Mindful that we're running out of time here, but I'll just note quickly. Yes. So the Trump administration, obviously, there's been unprecedented obstruction and disruptions at the agency level, and processing times have slowed across the board. Denials have increased. We're hopeful to see that all turning around. For example, at the beginning of Trump's term, there were 30,000 pending immigrant visa applications. Meaning applications by individuals outside the U.S. looking for green cards. There are now over 380,000. Wow. So we're hopeful, there's a change in tone immediately. We're hopeful that will become practical and that things will speed up, fewer denials, fewer pushback, less pushback. We can't count on that happening immediately necessarily. It's going to involve changes in staffing, changes in policy at the agency level, and
perhaps building back the State Department.
Yes, very depleted at the State Department.
Yeah, unfortunately. Now, Sharina, what can you tell us about the entrepreneur parole?
Sure. Can we move to the next slide? So this, like I said, was introduced during the Obama administration back in 2016. And what it really was geared to do was to really allow entrepreneurs to come to the U.S. for a 5-year period who receive funding from U.S. sources and actually build the business, build the entity. It was challenged by during the Trump administration, and I think it's still in play. It's still there, right? It was very hard to get these approved. So my hope is that we can actually start moving these applications through and getting our entrepreneurs this parole.
Yeah, since this was one of the then Vice President Biden's programs, we think that this is going to be coming back, and we are not we don't have a confirmation on this, but we're positive that this is going to have some hope in the near future. Next slide, please. Yes, we have handouts available because for reviewing more details of the visa and etc. Now we're going to be transitioning to some tax aspects of this, and after that we're going to be answering all of those questions that you posted. Thank you for that. And if we don't have time, we will make sure to post these questions for you. Now, Chris, working for many years with you in some joint projects, what are the pitfalls that our entrepreneurs have to be aware and mindful of? What are the landmines that we can talk about briefly?
Yeah, my expectation is that the folks on the call may be the sole resource for the company from a tax perspective. And they might be wearing 8 or 9 different hats and might have a very limited understanding of tax. And maybe they look at it from a protectionary standpoint rather than sort of substantive planning. So I think really the point of this presentation is to highlight some of those sort of considerations and pitfalls for companies that are sort of starting up or early stage companies, to make sure that they're not putting themselves in a worse position. During the presentation, there will be I will give an overview of the U.S. tax system, which I think is somewhat helpful, but you'll see that there's probably some granularity in those slides that I'm not going to touch on, and that's intentional. I want you guys to make sure that you have at your fingertips this resource after this presentation to look at that. But I think we're going to be focusing really on a couple aspects, and that is structuring considerations, at least initially when getting funding. Also talk about mobile employees and some of the pitfalls to look out for from a taxation standpoint, and also discussing transfer pricing and documentation, because in my experience, I've seen some early stage companies have more pressing needs than to document an intercompany transaction, and so I want to just discuss that. But go ahead and go to the next slide. And I like to start with this slide because it kind of sets an expectation, especially for those folks that are obtaining or going out and looking for funding. Now, if your startup is a U.S. company, I think the considerations are more straightforward. When you go to those investors, they're gonna likely invest in your U.S. company. Obviously, you'll have a back and forth on some of the terms, but really some of the more interesting questions come with companies that are not U.S. companies. Say you have a startup. I deal with a lot of companies with entrepreneurs from Australia. So maybe they'll start their Australian company, they'll build it to scale, and then they'll pivot to obtain funding in the United States. And so when they're making their rounds to investors, it'll be good to sort of understand what you might see, because a lot of the U.S. investors won't invest into a non-U.S. top company, and this isn't necessarily a tax issue. It's more, if something goes haywire, they don't potentially need to go to a court, say in Australia, to litigate the issue. So I think they're more comfortable investing into a U.S. company.
Now,
and so
let me walk you back, and I have a very simple question.
Yeah.
For the tax purposes, when I'm coming here to the U.S., does it matter that I have an LLC, C Corp, or any other form of entity? Is there any standard recommendation?
I think if you're going to get investing, they'll make you typically do a C corporation. You can do an LLC, but it's taxed differently from a U.S. tax perspective based on whether you have one owner or you have more than one owner. So it can get a little complicated with U.S. LLCs in that some are treated as corporations, some are treated as disregarded entities, and some are treated as partnerships. So it can get a little bit complicated in the entity setup. So I think most of the time what we see is just regular old C corporations.
Thank you.
But again, they'll likely want you to be in a top C corporation. And so what they'll require you to do is sort of undertake what we call a flip transaction. And that is essentially just interposing a U.S. company on top of and in between the existing shareholders and the non-U.S. entity here, say the Australian entity. And so how they do that is the existing shareholders will form a new U.S. company and will contribute the shares of the existing Australian company to that U.S. company in exchange for shares of the U.S. company. So afterwards, the structure is existing shareholders own a U.S. company, the U.S. company owns the Australian entity, and the Australian entity owns, is the business, is the historical business. Now, there's no U.S. tax issues there, but what you have to be careful of is the tax implications for the existing shareholders and the jurisdiction where they're located. Because when they contribute those shares in, say, the Australian company to the U.S. company, it could be subject to tax. Now, Australia, for example, has specific rules that allow for deferral of tax on something like that under the script for script provisions. And so you just need to be mindful of the existing shareholders when you're flipping into this top level U.S. company, that you're not causing or creating any issues for those existing shareholders. But from a U.S. perspective, they want you to bring this stuff into the U.S. so that they're happy to do that.
Now, has there been a change between the pre-2017 tax regime and the new one?
Well, we'll certainly get into situations. Yes, there are certainly, and I'll go into later slides that discuss those issues. But from just a formation situation and doing these flip up transactions, it's generally mostly the same. But I think it's a good segue into sort of discussing what the high level considerations are of the U.S. tax system, because as Farshad said, in 2017, at the end of 2017, the Tax Cut and Jobs Act made material changes to the U.S. tax code, especially on the international side. And again, we'll briefly touch on those, but this slide sort of discusses what that old system looked like. And essentially, this system really pushed companies to move their profits and move their activities outside the United States, and really at a pretty early stage. As we note there, the U.S. tax rate back before tax reform was 35% corporate tax rate, one of the highest in the world. And generally, if you could avoid some certain anti-deferral regimes here, subpart F, which I'll discuss in a little while, effectively the foreign profits of your foreign subsidiaries, your profits of your foreign subsidiaries were not subject to U.S. tax. So they could grow sort of in a tax preferred jurisdiction, say Cayman Islands or Ireland, which is a 12.5, and just sit there and accrue, and it wouldn't be taxable in the U.S. until it was distributed up as a dividend to the U.S. So you had all these major companies that were doing advanced tax planning to move their stuff offshore. And it's not just the big companies, though. It was even smaller companies, early stage companies, because what was happening was when you move this IP offshore, it's a taxable transaction from a U.S. perspective. And so if you're doing it at a very mature stage of development, it was creating a lot of a tax cost, a real tax cost. And so you saw a lot of early stage companies doing this sooner and sooner and sooner when that IP value or the company value was so low that it didn't have a immediate tax impact. But this was under the old regime where we're sort of pushing people offshore. And so now if we go to the next slide, we talk about what happened? What did they do? Well, first of all, the big one was that they reduced the corporate income tax rate 35 to 21%. And this is very, this is very close to EU jurisdiction tax rates. So there wasn't a major push for companies to move offshore to get a preferential rate, because 21% in the grand scheme of things, yes, maybe they could get a little bit lower rate offshore, but it caused operational issues, investment offshore that they didn't really want to do. And then there's also a major anti-deferral regime that was introduced, and that is Global Intangible Low Tax Income. The acronym is GILTI, of all things. And essentially what that did is it brought into, as I said earlier, typically your profits of your foreign subsidiary were not subject to U.S. tax, and they'd sit out there and wouldn't be taxed in the U.S. What GILTI does, it actually puts into the U.S. a portion of that income earned by the foreign subsidiary into the U.S., even though there's no dividend distribution. It's taxed at a preferential rate, but it's still taxed, meaning that your foreign subsidiaries who you thought were outside the U.S. tax net are now having some of their profits put into the U.S. and taxed in the U.S. through your U.S. company. So anyway, that caused a lot of issues with how companies were doing their international tax planning. And the other big thing that was introduced was FDII, Foreign Derived Intangible Income. This is a benefit for the U.S. company. Again, people were moving their IP offshore so they could get a lower rate offshore. And typically when you did that, you moved your foreign IP offshore. So then you could easily so then what would happen is the foreign subsidiary would sell to foreign customers and accrue sort of the foreign sales in that jurisdiction at the tax preferred rate. So the U.S. said, well, let's stop incentivizing companies to do that. Let's just give the U.S. company a preferential tax rate on any income they earn outside the United States. And that's what this FDII regime does. It gives the US companies preferential tax rates for income earned from non-US sales, non-US services.
So I have a question, Chris. Let's
Yeah.
say I'm a startup and we have been successful, our operation expanded in the US, and I'm interested to open up the international, but I'm not really ready to go all the way and open form an organization, entity, etc. I'm just going to send a couple employees to different countries and start just testing the water, see how this is going to unfold. What are the considerations? Is that going to create any tax liability for me?
Yeah, no, it certainly will. And we certainly discuss that a little bit later in the slides of these mobile employees and how they can create US tax issues. And in the interest of time, maybe we can move forward. Again, I've given you I've laid out some framework of, and in the slides, there's US tax issues, more details of some of the US tax issues. But I think if we could maybe move forward a few slides, and I think if we can go ahead and move forward. One more. Okay, so this is probably likely where you're sitting right now. You're a U.S. company and you're worried about foreign tax, being subject to foreign taxes based on the operations of what your U.S. employees or potential contractors, who may not be contractors but employees, are doing offshore. And really, this pertains to U.S. companies, having operations outside the U.S. as well as your foreign subsidiaries and what they're doing in other jurisdictions outside their own jurisdiction. And so we'll walk through some of these key considerations related to permanent establishment and withholding tax on the next slide.
Can you briefly explain the permanent establishment? Oh, great. Now,
yeah,
and that's something you always hear in the international tax context and also the subpart F, etc. Go ahead.
Yeah, no, it's great. So the question becomes, when is a U.S. company subject to tax in another jurisdiction based on the activities of that company in that local jurisdiction? And permanent establishment, or really nexus, is one of the key considerations for companies that may have mobile employees. Obviously talent is everywhere. So a U.S. company might find a developer, say in Israel or in India, and or maybe a VP of sales. Maybe they have a really good salesperson that's located in the UK. And what risk comes with having employees located in these different jurisdictions?
Yeah.
And so the framework for determining whether your U.S. company is subject to tax locally is sort of this nexus or permanent establishment consideration.
So
effectively, what level of activities do you have to have in that local jurisdiction to create a sufficient nexus that the U.S. company is now going to be taxed in that local jurisdiction? And so the consideration is twofold. First, you look to see if there's a tax treaty between the jurisdiction where the employee is working and the U.S. jurisdiction, the jurisdiction where the company is organized.
Yeah. So from what I hear, I mean, we are on 11:50 and we have 10 minutes to cover the Q&A. But from what I hear is that you're not really safe if you say that, oh, I'm not going to establish an entity there. By virtue of sending and having some operation, you could actually trigger the permanent establishment and the tax liability in that jurisdiction, right?
Yeah, there's two ways that it's created via a treaty. If there's a treaty between the countries, typically you'll have a taxable nexus there if you have a fixed place of business, an office, think of warehouse. There's some exceptions if you have sort of a warehouse or a factory, but generally a fixed place of business will create a PE. Also, if you have employees there, and they have the ability to conclude contracts, and they actually do conclude contracts, that will create a permanent establishment risk. So the point is, if you have people located in a foreign jurisdiction, be mindful of what they can do. They can do a lot of things before creating a permanent establishment or a nexus. It's when they start signing contracts that you probably are going to have a problem. So you want to monitor that, monitor what they're doing in those jurisdictions, and make sure that their activities do not rise to the level of having a permanent establishment. And then, so that's certainly one of the bigger issues is PE, and especially in COVID times. You might have an employee that said, I'm getting out of the U.S. I'm going to go to a beach in Greece for the next 6 months. You have to manage the PE risk by understanding what that person does, and making sure that they do not undertake activities sufficient to create a nexus for the U.S. company, or the U.S. company might be subject to tax there.
Yeah, that's an excellent point. That also created a lot of questions for us in the immigration world when people started to be mobile and going to different places in terms of what the changes have to be made in the applications, etc. Well, thank you very much, Chris. I think we should look at the questions that are posed and answer some of those. Now, Sharina, I think you briefly touched that question asking about do you have to have really big income on the corporation when you it has to be profitable actually for the L visa sponsorship. Can you touch that, clarify it?
Yeah, I mean, in the startup world and how businesses normally start, it's really difficult to become profitable, right? If you become profitable within the first year, that's amazing. But most of our clients are still in really the startup phase. And so what you really have to show is that you have the funds to be able to hire US workers, and that you're actually actively running your business, your operation at a managerial level, so that you can be able to renew your L1 visa.
Thank you. We have a question posed that an individual had an O1 but went to visit the family. They don't have a visa, and since the consulates are closed in that country, could they go to a different jurisdiction to get the visa? It's kind of like selecting a different forum. What are the options? Sharina, you can.
Oh, I thought it was for Nate. Nate, you're O1.
Nate?
Sure. Yeah, it's an unfortunate situation, and we have had some people in similar situations stuck because they can't get an appointment, because they can't get a waiver to get past a ban. That is tricky. Going to Mexico or another forum, it's a little bit risky. The questioner may want to reach out to us, and we could discuss in detail the risks. You can apply for a visa at any embassy or consulate, but there will be issues sometimes if you're applying someplace and it appears that you're there just because you're forum shopping.
Yeah, there's a general rule, we call it TCN, and there is no prohibition to go and get a visa at a different consulate, but they generally look at why you are there, and there should be a meaningful reason. So for TCN, you have to generally show a tie to that country. If you are there for a reason and you're allowed to stay, that's kind of an indication for the consular officer that could take over your case. Because none of the consulates around the world, they're already overworked. They don't want additional work. And that's the reason. They say you have to go back to your own country or the country that you have ties to and then do it. I have a client that had a student visa in Netherlands, but was a citizen of Pakistan. But yes, they were able to secure a visa appointment by showing the proper visa that they're in that country legally. Now, one of the other options.
I would just note. Oh, sorry, Parshad. I would just note that the other option, if you can't get an appointment in Europe, you can try to apply for an emergency appointment. And
exactly.
you can apply for waivers to get around the COVID ban.
Most of the consulates are closed, but they do have still their processing open. and if you make a request to them, they may respond, but you have to state reason. And generally, they have some instruction on their site to show to direct you how to make an emergency request. Okay. Sharina, what can we say about the H-1B, the new regs that were discussed? Do we know what's the latest on that?
We don't know, and that's the hard part, right? You know, Biden talks about a prevailing wage system as well, but we don't really know what's going to happen, and all of this is all in play. So for right now with our clients, we're just letting them know we just have to move forward with what we know, especially during the H-1B cap season, and we'll provide more information as we get it.
Yeah, but there was one regulation that was supposed to be published regarding the H-1B, which it has not. So that probably will be withdrawn by the Biden administration. So
yeah, typically when a new president comes in, they will review all the Federal Register publications and then make decisions from there on how they want to proceed.
So
I think there's a question for Chris here on a tax one.
Which one? I'm not seeing it.
Was we are an early stage company with plans to allocate equity to employees located in US and India. Can you please talk about tips on that to avoid excess taxes on vesting, exercising of options?
Yeah, there's certainly, thank you, Sharina. There's certainly sort of rigid rules on valuation aspects of stock options and restricted stock units that was in the news many years ago. But there are certain mechanisms you can use, especially 83B elections, which sort of move up the timeline on taxability, which potentially you're taxable at an earlier point on less value. So there are certain tips, there are certain things you can do, but I'm happy to sort of take that one offline as well, because it is a little bit more substantive than probably next minute or two.
We have a question. What is the option for my Canadian-born kids, Canadian citizen, to get green card while I'm on TN? Sharina?
It's the same option as you. They derive their green card through you. So you can pursue, some of the options we talked about, which was the EB-1A, extraordinary ability. We didn't get to touch into the national interest waiver, but we have a lot of entrepreneurs who are able to obtain visas. Green cards under the national interest waiver prove that the work you're doing is going to serve the US's interest. And it's you can't find someone like you here in the US. But unfortunately, there's nothing special they can do that you can't do. They all depend on you. Unless, of course, you have a US citizen child, but that's going to take 21 years before they're of any benefit to you in terms of immigration.
Nate, can a Canadian citizen visit US for sales activities without any visa? If not, what visa would be needed?
So I'm going to give a lawyer answer and say it depends. I'm not sure what is meant by sales activities there. The relevant questions I think I would be asking are, what exactly are you doing? What are you selling? Who are you selling to? How long do you anticipate that you're going to be in the US? So under a B1, B2, you can come and negotiate contracts and make commercial transactions. But if you're talking about your job is software sales, let's say, and you're going to spend 6 months in the US doing your normal job, then probably not.
Hey, Farshad, can we move to the last slide? Because I think a lot of people are asking about our contact info. So it's all there.
And someone posted a question about the H-1B. If they're on H-1B, can they do day trading before the office hours, like at night or early in the morning? Sharina?
That's funny. We have a lot of day traders now. I think where it really talks about is, are you actually working for someone? If it's merely just an investment and it's like your hobby and that's what you're doing is just investing your funds, then I think it's probably okay. You know, I think if it turns into more of something where the government can claim you're actively working and working unlawfully, then that becomes a problem. But if it's just for your personal gain, then it's probably okay.
Thank you, Sharina. Unfortunately, we are out of time and we have to finish our webinar. But we have a number of questions that we received on the chat. We will make sure to answer those. We also are posting our panelists' contact information. Please feel free to reach out, Chris, Sharina, and Nate, and myself. We will be happy to answer any questions that you have. As Sharina mentioned at the beginning, this has been certainly a challenging 4 year for immigration, and we are looking forward to see the upcoming changes by the Biden administration, and we will make sure to take those as quickly as possible, analyze it, and push it out to our members, to our clients, and also post them on our website so you can frequently visit and get the latest information. I want to thank Chris. Thank you, Chris, for participating. Nate and Sharina, thank you both for putting time and preparing for presentation. You all have a good day. Thank you.